Okay, here we go. We're doing the last essay, 2023 July. Question one. It looks like I believe this is a partnerships essay. I have not gone through it yet. So the first time I'm going to see the fact pattern is right now. Which of these defendants might reasonably be found liable for damages arising from Priya's car accident and why? Okay, so we have Priya sued Amy, ABC, Bob, Carol, and Sam for damages arising from the car accident. So we got Amy, ABC, Bob, Carol, and Sam. Okay, I assume Amy, Bob, and Carol are part of ABC. And who's Sam? Probably the driver, who knows? I don't know who Sam is, maybe a passenger. Okay, Amy, Bob, and Carol are partners in an ABC law firm which operates under a general partnership agreement. So that means they just share profits, and losses equally. That's what a partnership is. And for a partnership, because it's so informal, you just need a handshake, no documents, no filing with the Secretary of State or anything like that. ABC provides all firm attorneys with cell phones to facilitate prompt attorney-client communications. Okay, that's very, very common in big firms. Any of your firms do that? Anyone's firm do that? Or is that kind of a thing of the past now? Because everyone has cell phones. Anybody? Anybody know of anyone who gets a cell phone? That's, you have a friend that carries two phones, their personal and their work.
Yeah, they just pay for my phone bill now.
Okay, they just pay for, yeah, that seems to be the easiest way to do things nowadays. Because people don't like having two phones. ABC has a policy that all firm employees must carry their work-provided cell phones with them at all times, and that all client emails must be responded to immediately, at least with a personal acknowledgement of receipt. I mean, believe it or not, One-Timers has the exact same policy in place. We have a company policy to get back to students as promptly as humanly possible. And that even when we hire people, we tell them, hey, you're on the clock on Saturday night. If somebody calls or emails on Saturday night, you might have to take 5 minutes to like go ahead and address it. Are you okay with that? So we actually say that in the interview. Sam, an attorney, well known for his many highly publicized trials, often works closely with ABC. Okay, Sam's on the call, but is not a party to the written ABC partnership agreement. So he works with them. Okay, so he's probably working with them as an outside counsel or some kind of independent contractor, not an employee. ABC believes that Sam's presence raises the profile and prestige of ABC. And that's fine. A lot of the times people do associate with somebody of well-known stature to help their brand. Sam leases an office in the suites of offices used by ABC, for which ABC charges Sam $3,000 per month. Okay, he's just a tenant. The ABC receptionist greets all clients of ABC and Sam, well, so do all receptionists in the same office. Nothing uncommon there. Sam uses the ABC firm name. Oh, wow. And telephone number on his letterhead. Okay, wow. So, why would he use the firm name on his letterhead? I can see having a general telephone number, but he's got the firm name. Wow. That seems like he is associated with. So to me, that might go to apparent authority. Wouldn't it make? I mean, that seems to me that this is a crossover partnerships and agency, which I never got any word about it being crossed over with agency. Apparent authority, what a reasonable third party would believe. Sam bills his clients directly for his services. Sam also receives 10% of the annual profits of ABC. Oh, so he is sharing in profit. Oh my goodness. I mean, he's about as much of a partner as I could think of. And what's on his letterhead, same receptionist, same office, same name. Although he bills his clients directly, he receives 10% of the profits. So he's getting a cut of it. So he is a partner, in my opinion. He's got to be responsible for something. After work one day, Amy was driving in heavy traffic to attend a baseball game when she received an urgent email from a client. So the fact that she's attending a baseball game, she's not within the course and scope of the relationship, of the employer relationship. I know that she's responsible for answering emails at all times and taking phone calls, which is customary. But she's not really doing anything on behalf of the partnership to benefit the partnership. She's what's called, what's that called? Is it a frolic and detour? It's a detour of her own rather than just a frolic. A frolic is when you are still working for the company, but you're just taking like a little detour, like using the restroom or going outside for a smoke, that's a frolic. Whereas I believe a detour is when you completely go off course and you're on your own personal time, which it seems like that. So frolic or detour. Okay. While briefly stopped in traffic, she attempted to answer the email on her work provided cell phone, which is very common. Due to this distraction, she negligently caused a car accident that was the actual and proximate cause of serious injuries to the driver. Notice how they give you breach the duty of care that they say she negligently caused. So you don't have to go into a whole negligence analysis. They give it to you. But she obviously owes a duty to other drivers on the road. She breached it by acting negligently, and we have causation, and then we have the serious injuries, which is damages. So they actually give you all the elements of negligence. You don't have to go through a full negligence analysis. Wow, this is all? Priya sued Amy, Bob, and Carol and Sam for damages arising from the accident. Which of these defendants might reasonably be found liable for damages arising from the car accident? Okay, so if she was acting on behalf of the partnership, then not only is Amy's directly liable. Everyone understand what that means? She's the one who caused the injury. She's directly liable. Whereas the other ones are vicariously liable, or there's a theory of liability that ABC is responsible for all its employees. But the big issue here is whether or not she was acting within the scope of the partnership. She clearly wasn't doing anything for the benefit of the partnership. She was attending a baseball game, but then there's the email is what caused the distraction. And by answering that, because of her responsibilities, does that make the partnership liable? And I think you can make a good argument that they are. To tell you the truth, I don't think there is a right answer here, because a court may say, no, she was on, this is something that people do when they're outside of work. This is not part of work-related scope. On the other hand, if you have a very convincing argument, you could say the only reason this accident happened is because she was answering the email, which she's required to do based on their firm's agreement, and therefore the firm should be responsible for it. So if that's the case, then who's going to be, so assuming that she is acting within the course of the partnership and for the partnership, ABC would be liable. Amy would also be liable, Bob and Carol clearly. A whole discussion about whether Sam, there is no apparent authority, by the way. There is no discussion of apparent authority because nobody's relied on Sam putting himself out there as a basis for liability. So this is just a 100% partnerships essay, in my opinion. I don't see anything to do with agency. The question is Sam part of the partnership? I mean, I think the biggest factor is he's receiving 10% of the profits. And because partners share profits and losses equally, I don't think he's sharing in the losses though, but he does use their letterhead. And that to me is a big thing. He puts their firm's name on his letterhead. That and the profits to me sway me in favor of finding that Sam is likely a part of the partnership, even though he's not part of the partnership agreement. Of course, you can make a discussion. I think the discussion can go both ways. So you're going to have a big discussion about the two big discussions here, which is really don't have a correct answer. Is number one, is Sam part of the partnership? Number two, was Amy acting within this course and scope of the partnership? Was she acting for the benefit of the partnership when the accident happened? So those are the two big issues. I'm having a hard time seeing what the hell else is here. To me, this is really a factual discussion on what is what. Huh. Let me hear what you guys have to say. What's going on here?
Jason, I had the same.
No, go ahead.
I had the same thoughts that about this is going to be between if Sam liable, see a partner because now he's going to be liable, and then the second part I went to about the company's policy about immediately responding, and then I went into a difference between like he had to go through email that's more complicated than like a text. So kind of I had to tie all that to he's kind of going to he's acting within the scope of the employment.
Yeah, okay. So where does that leave us?
So then the partnership's also liable too.
Because of the fact that she was acting within the scope of it?
Within the scope of you got to respond immediately, and then
Yeah.
how more complicated it is to sit in a car and email versus text. You know, email, you gotta like think, you gotta give a full sentence and all that.
Yeah,
Just kind of,
and of course, I'm sorry, Pablo, go ahead.
no, that's it. Sorry.
So, no, so I like what you're saying. So one of the things I would say is like, well, she didn't have to answer it then. Immediately does not mean immediately. It means, within reason. So let's see what it says here. And so the outline, within the scope of the partnership business. A partnership is bound by the acts of a partner when that partner acts within the scope of the partnership business. This means the conduct must have been committed in the ordinary course of the partnership business and in furtherance of their interest. In other words, the partnership is not liable for acts committed by a partner that are not intended to serve any interest of the partnership. So this looks like it is serving the interest of the partnership, in my opinion. Okay. And we have, it says, when a partner deals with third parties, look to the rules of agency for guidance. But that had nothing to do, we're not dealing with any third parties in terms of like, they're not dealing with each other in terms of business. So all partners, let me do this. Okay. All partners, even those with proportionally small entities, are jointly and severally liable. So joint and several liability is going to be a big issue because guess what? Sam, how much can Priya recover from Sam? Amy, how much can Priya recover? Let's say her damages are $100,000. How much can she recover from Sam? Anyone want to answer it?
100 grand.
100,000. How much can she recover against Carl?
100 grand.
Same answer for everybody. That's very heavily tested on the MBE portion of the bar exam for torts. So, let's see here. Yeah, that's what I'm saying. With no fiduciary obligation, no settlements of accounts, vicarious liability, we have that. So we have obviously vicarious liability. I don't know how that got bolded. We have this as well. So liability for partnership obligations. Suit may be brought against any one of the partners or the partnership itself. If all parties are sued, satisfaction must first be sought against the partnership. If the assets are not sufficient, then the judgment may be enforced against the partner's person. In other words, the creditor first must exhaust the assets of the partnership before going after the partners personally. So that means Amy's going to be primarily liable because she caused the accident. That's without even hesitation. ABC will be responsible for everything, but you can't go after Bob and Carol personally or Sam unless the partnership isn't able to cover this. So you must first exhaust the assets of the partnership before going after one of the partners personally. A partner who pays any part of the judgment is entitled to indemnification. So everybody can get indemnification against Amy. Yeah. There you go. Okay. How's that, guys? Let me see this. Okay, I'm just going to copy one more thing. There we go. Okay, let's hear some comments. What do we got?